Our position is that that's Brady, and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady in our position.
The experience has been this office has been very sensitive about Brady. We all should be.
A Texas courtroom reviews a serious case as a man faces charges of aggravated assault and family violence with bonds already set at tens of thousands of dollars. The defense argues the bond increase isn't justified, claiming the alleged victim may even want the charges dropped. But prosecutors warn the court about public safety risks and raise concerns about possible contact with the victim behind the scenes. Now Judge John Stevens must decide, should the bond stay high or be lowered?
This is
It's not a indicted case, it's the one you.
Oh, this is when you set the bond
The
on.
bond thing,
Oh.
there's.
I know about this one.
Yeah,
Yes, okay.
you just wanted to go over it like today.
All right. There's a matter that was presented to the court yesterday by the Criminal District Attorney's Office for Jefferson County, Texas. And you are Charles Wilson III?
Yes, sir.
And you were here with Mr. Adams, your attorney, and the state's attorney. The state of Texas filed a notice for a review of a bail decision. You had been placed on $65,000 bond for an aggravated assault and a $15,000 bond for family violence. And the state of Texas, the district attorney's office deems that amount is insufficient under the law to ensure that you will properly appear and answer before the court and to ensure the safety of the community and the safety of the victim. And for those reasons, they ask for a review of this bond decision. And the court has 24 hours to make a decision. And so the court made a decision yesterday because of some emergency matters that prevented all of us from getting together, but I had to make a decision. And this court did make a decision finding this finding this request in good cause, for good cause. And upon reviewing the public safety report, the probable cause affidavit, and the other documentation in this file on these cases, the court raised your bonds to $100,000 in each cases, and also ordered that if you post these bonds, you must remain at home. You would be on home confinement, except for allowing to leave home only for necessities of food, medical care, and meeting with your attorney. And you must travel to and from your house in the most direct route possible. You must have a GPS device if you post these bonds so that we know where you are at all time, and to ensure that you're not violating these conditions. And also, I think those are the essential features of what the court did. Now, because the rule of law states I have to make a decision, we couldn't get together. I asked you and your attorney in the state to have a hearing today to show cause why and present any evidence why the court's decision should not be continued and enforced based upon what the court deemed yesterday. And I'm giving the defense an opportunity to be heard and to present any additional evidence you want me to consider. And so I will consider modifying the bond decision if I find good cause from evidence presented. Go ahead.
Yes, Your Honor. Specifically, Judge, under 17.028, it's the state burden to show that the safety of the community and ensures that the safety of the victim of alleged offense warrants this increase or request to review his bond. Your Honor, we ask that the state disclose you what we would believe to be Brady information as it relates to the state's burden as to safety of the community or the safety of the victims. It's my understanding, and I would ask that the state to disclose if this is true, that the alleged complainant did not want the bond to be increased, one, and that two, in fact, this Tuesday, she went to the district attorney's office to have the charges dropped. If that is true, and that would be Brady, that would clearly be Brady for purposes of a bond hearing. If she in fact went to the DA's office to have the charges dropped, and if in fact she did not seek to have this bond increased, then on the legal issue of 17.028, safety of the victim, that's clearly Brady, and that would go to that particular, that's my position. My position would be that that would be Brady, and I would ask the state to disclose whether in fact.
And how does your client know that she went and did that? I didn't tell anybody because I don't know about that. How did he know? Has he been in contact with the victim, which he's not supposed to be doing?
Well, let's say this. If in fact that is true,
Yeah.
again, my
Let's keep the
position,
if y'all want to conduct a hearing on your own, that's fine, but
I think that that's Brady. That's sorry.
the court's decision, the court's decision, even though the state of Texas always has the burden of proof in these matters because of the presumption of innocence standard, this court still has its own independent access to the probable cause affidavit and the criminal history, which I am required by law to review in determining bond issues. That's why I made my decision and found that the bond was too low and not appropriate under the circumstances this court reviewed. I'm giving the defense an opportunity to present any evidence you
And I have evidence
to that the court will consider in whether it will modify my bond order from yesterday. Go ahead.
Right. Well, Judge, Mr. Laird says that he's unaware of that, but if in fact that is true, our position is that that's Brady, and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady in our position.
The experience has been this office has been very sensitive about Brady. We all should be. We all are, and I've not found them to intentionally.
No, I'm not saying he's not
Brady material. They honor their oath and conduct it responsibly, just as you do in your.
Yes, sir.
Go ahead.
Judge, I would just ask that, I understand he can't do it now, but at some particular point in time, since he does not know, that he look into whether or not the lady came up with the drop charges, and he look into whether or not she did not pursue this. But I got evidence other than that, but that's why I got other evidence.
Okay, that's the court will note that, and it's in the record. But at the end of the day, the decision is in the executive branch of government, not her.
Right.
Somehow, some way, she was a complainant somewhere along the line. And when that happens, then the executive branch of government takes over and does what it does under their responsibilities of the oath that they have taken under the Constitution and the laws of the state of Texas and the United States. So I don't find that they've done anything inappropriate in this case, except follow their oath. And we've had situations where complainants change their mind for whatever reason. The worst thing that can happen, though, is if they decide to change their statements of victimization based upon influence or coercion or even contact on behalf of the defendant, it would be catastrophic for you. Because this court takes no prisoners when that is found to be done. You cannot disrupt what this Constitution stands for and what the laws stand for. And that's what happens sometimes when people behind the scenes try to influence others who are involved in the criminal process improperly. That if that is done, it will be dealt with severely. But nonetheless, I don't have any reason, I don't have any information before me to change what the court's decision was yet.
And,
That's why I'm giving y'all a chance.
I'm gonna call my client as a witness.
Charles Wilson III,
Yes.
raise your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right.
Yeah, speak out.
Yes, sir.
All
Your
right.
hand, thank you. Go
All
ahead.
right, Mr. Wilson, you understand that I'm not gonna ask you any questions at all about the facts for this particular offense. I'm asking you nothing but argument. You understand that?
Yes, sir.
And you understand on our rules of evidence, if you testify on a preliminary matter, does not subject to the cross-examination for any other issues. The only question that I'm asking you on about is for financial abilities, right?
And before you get through, I don't think that's accurate. I think I can cross-examine him on any issue. Because part of the rules, or part of the reason the judge made his decision was on the safety of the community, so I can talk to him about the offense. So before you put him up there, you better get a ruling.
Judge, I don't think that he's subject to cross-examination. All I'm asking him questions is about his basic income and his ability to afford a $65,000 bond, and asking him about his income has nothing to do with whether or not he committed family violence against this lady. And
I think it does. The issues on bond are the ability to follow the bond conditions and whether his release would be a safety to the community or the victim or others. They can go into this because part of the bond conditions is not to include not to commit first thing, don't commit another offense. But it opens you could possibly open the door for this subject matter to be allowed. Yeah, I got to take a break.
no,
Right now. Stand by. I'll be right back. Thank you.
In cases like this, it's not just about the charges. It's about risk. Because when the court believes public safety is at stake, everything changes. And sometimes, one decision about bonds can decide what happens next. Backhand index pointing right. Do you think the judge made the right call by increasing the bond, or was it too harsh? Backhand index pointing right. If the victim wanted the charges dropped, should that change the court's decision?